Okay. Right. Oh, well, that's great. Now it's working. So welcome everyone to the second session, or the third, after the great keynote this morning. My name is Eleni Methymaki, and I'm a lecturer in international law here at Glasgow. And I'm looking forward to an exciting panel on people and effects of the ICJ, where we'll be speaking about the role of judges, counsel, and the way the procedures of the court have evolved over the years, including in how judges ask questions of counsel and parties during proceedings. And without further ado, I'm going to introduce the first speakers. Dr. Cecily Rose, who's an associate professor of public international law at the Grotius Center at Leiden University, and Dr. Michael Becker, an assistant professor of international law at Trinity College Dublin. You have 15 minutes. I will show. Will you be coming up? Yeah, that's great. I will show you the time in when it's 2 minutes remaining, and yeah, no wait.
So thank you very much. Can everyone hear me? Yeah? Thank you very much for that introduction, and thank you to James and Christian for inviting us to participate in this conference. Now, our project concerns questions posed by the bench of the ICJ, not only to counsel, but also to experts and witnesses. And we're talking here about questions posed over the entire history of the court. And in terms of some background on this project and where it comes from, it emerges out of a shared research interest about how the court deals with evidentiary issues, how it engages in fact-finding, not only regarding questions to counsel, experts, and witnesses during oral hearings, but also things like how the court engages with experts, court-appointed experts, but also party-appointed experts, and site visits, which we've written about before. So I'll begin then with our anecdotal observations dating back now some years, back to the time when we both worked at the court. And at times we wondered what oral pleadings were contributing to the judge's understanding of the matters at hand, the legal argumentation, the evidentiary issues. And I think it's fair to say that overall our sense at times has been that the judges haven't made full use of the opportunity presented by oral hearings to probe counsel, and in some cases also witnesses and experts. And yet we've also anecdotally observed that at times the frequency of questions seemed to increase. So in particular, in the early 2010s, when we were both at the court, it did seem at times that there was an uptick in questions. And this was then reinforced by commentary around the 70th anniversary of the court in 2015, when judges and other commentators observed that there appeared to be a trend towards more active questioning. So these are the origins then of this project, which concerns in part whether there has been such an uptick, along with a number of other issues, which I'll elaborate upon in a moment. So in terms of the importance of this project, why we decided to pursue it, we're interested in testing some of our assumptions about questions or the lack thereof from the bench. So I'll turn over the floor.
Thanks, Cecily. So at its heart, this is a quantitative empirical research project. And that first question that we wanted to get at is what Cecily outlined. Has the frequency with which judges have asked questions increased over time? And so we started off, how we're going to investigate that. Well, we went and gathered all of the data from more than 150 oral hearings going back to Corfu Channel to identify all the times when judges have asked questions to the parties. So right now we're setting aside the questions to experts. This is just about questions to the parties or to counsel. And by hearing, we mean the entire hearing. So I don't mean every sitting, but all of the sittings related to a procedural phase of the case, right? So if the court meets for 6 times to hear preliminary objections. In one case, that's what we call a hearing. That's the unit of analysis. All right, so what did we find? Not sure how I use this. I don't know. There you go. Right. So what did we find? Well, somewhat to our surprise, the data reveal no discernible trend towards more questions being asked. Instead, the frequency of questions seems to fluctuate quite a lot, even as the court's caseload has in fact increased fairly dramatically over the past couple of decades, and in fact quite a lot the last 5 years. So this graph that you can see on the screen displays that data based on the average number of questions asked per hearing during distinct 3-year periods that correspond to ICJ presidencies. I realize there's a lot of different factors there to take in. We chose that unit of analysis, that time period, because we have an intuition about the possible influence of who the president of the court happens to be at any given time on whether there is more or less active questioning from the bench. So we broke it down into these 3-year periods, and you can see on the graph that the line goes up and down quite dramatically. So that's the average number of questions per hearing. We go to the next graph. This is something slightly different. We were also interested in the frequency with which a hearing involves any questions, at least one question, rather than the average total number of questions asked per hearing. And here the data are similarly ambivalent, I would say. So in some 3-year periods, you can say nearly all hearings, 100% of hearings, involved at least one question. But then in other 3-year periods, the percentage is much lower. So that means there might have been 10 hearings and only two of those hearings involved some number of questions. We also looked at this at the level of decades, see if that smoothed out the data a little bit. And basically it shows the same thing. So what we see here, as Cecily suggested, it does show a bit of an uptick in the frequency of questions from the bench in the early 2010s. But that hasn't proven to be part of a sustained, ongoing trend towards more active questioning by judges. Now, it does help to explain why Cecily and I, along with other close observers of the court, had the impression at that time that the court was becoming more active. But this seems to have been a good example of anecdotal fallacy, where we're drawing broad conclusions based on just a snapshot of evidence from a very limited period of time. We do think that this data is interesting, though, for a few reasons. So first, it seems to show that commentators have maybe overstated a perceived trend towards more questioning, an impression that can be bolstered by the court's more active caseload in recent years. We have more hearings, and that might mean there are more questions in the aggregate, but it doesn't mean that questions have become more frequent. And secondly, I think that this data shows that commentators have maybe understated the role that questions have played or the frequency with which questions featured in the court's work in its earlier practice historically, with questions being at least somewhat more common than is often assumed. Overall, if you look at the entire 80 years of the court's practice, on average, the court poses around 1.5 questions per hearing.
And so we hope that these graphs and our findings so far, which are just preliminary, illustrate the importance of empirically testing some of the assumptions that we have about the court's practice. And now I'm going to elaborate on the other aspects of the study more broadly. We're not just looking at the frequency of questions over time. So in terms of what we're investigating more broadly, we're interested in the circumstances in which judges pose questions and any apparent trends or patterns there, and also the impact that such questions have on judicial outcomes. So with the help of a research assistant, we have gathered quantitative data on all questions posed over the course of the court's history. So that's about, according to our counting, about 350. And then we've gathered a lot of data about those questions, the time period in which they were posed, and we've counted that by the 3-year period corresponding to the person who is the president at the time, so triennial periods. We've indeed gathered information on who the president was, the recipient of the question, whether counsel, expert, or witness, mostly counsel, but also experts or witnesses, the subject matter of the case, and also then the procedural phase at which the question was posed, and then information about the judge who posed the question. So the judge's educational background, professional background, whether they were a member of the International Law Commission, all with theories about why these things might matter. And the age of the judge and how long they'd been on the bench at the time the question was posed. And then we've gathered information about the type of question, whether it was of a legal character, probing counsel, for instance, about legal argumentation, or whether it was about something factual, or whether it was asking a counsel to provide an undertaking, a commitment of some sort. And so with all of this data, which is now quite abundant, we're now at the stage of really cleaning up what we have and putting it in final order so that we can generate descriptive statistics and hopefully also identify some correlations between frequency of questions and surrounding circumstances, such as the background of judges and the types of cases. So with that, I'll turn the floor back over.
Right, so that gives a sense of the quantitative types of questions that we're still planning to investigate. But there is then this question that Cecily hinted at, that we're interested in trying to figure out, well, what difference do these questions make? Or properly said, what difference do the questions and the answers make to how the court actually reaches its decisions? And so this gets a little bit away from the quantitative and more into the qualitative, of course. So how can we decide whether something makes a difference or has some kind of impact on the way the court decides things? And that's something we're still thinking about. But our starting point here, I think, is going to be to identify those decisions where the court expressly references the fact that a question was asked counsel during the oral proceedings, and here's the response that was given. That's one universe of cases. But then there's a broader universe of potential cases where the court's judgment actually does deal with the subject matter of the question and the answer without expressly referring to the question. So that's going to be a little bit trickier for us. But ultimately, we want to figure out whether certain types of questions maybe seem more consequential than others, whether based on the procedural phase or the type of case that it is, and so forth. Now, I'm sure given the people in this room, all of you or many of you can think of some case where a question seems to have had some kind of impact on the outcome. And I thought I would just mention a couple so you see what we're talking about. So we're pretty interested in, for example, maybe questions are more important at the provisional measures phase, when the court is operating on a limited factual record and under time pressure. And we saw an example of this pretty recently. This was in South Africa's third request for provisional measures in its case against Israel. And this was the request relating to events in Rafah at the time, back in May 2024. Final day of the hearing, Judge Nolte asks Israel to provide more information about the existing humanitarian conditions in the designated evacuation zone. How is Israel going to ensure safe passage? How are they going to provide aid to people being evacuated and so forth? And then when the court goes ahead and indicates the provisional measures requested, this was the order where the court ordered Israel to halt the military offensive in Rafah. This was a 13-2 decision. The court expressly noted that it was not convinced by the response to Judge Nolte's question. Now, we can't know if the court would have indicated provisional measures anyway, regardless of whether that question was asked, or if Israel had answered the question in some different way. But the language the court used suggested that this mattered to some of the judges. Another example I'll jump to, so on the merits, for example, just one example, if you can cast your mind back to the whaling case. So about 10 years ago, Australia versus Japan, this was a case that saw a very active bench because we had witnesses, we had experts, but we also had questions to counsel. And one question in particular, I think, jumps out. This was a question from Judge Donahue, who asked Japan what kind of analysis it had done of the feasibility of using non-lethal methods rather than killing whales to achieve the research objectives that it claimed it was trying to accomplish. And how did the analysis that Japan had done affect its sample size determination? So the number of whales it said needed to be killed. The court then devoted no less than 8 paragraphs in the judgment in that case to talking about that issue, to talking about the question and Japan's response to that question, with the court ultimately concluding that there was no evidence that Japan had studied the feasibility of non-lethal methods to achieve its research objectives. So this wasn't dispositive. This isn't the point that the entire case turned on. But I think it certainly looks like one of several points that led the court to its ultimate conclusion, which was that the implementation and design of Japan's program for whaling wasn't reasonable in relation to its objectives. So a really interesting example, I think, of very close engagement with this question that was posed, and indeed the response, or what the court almost treated as a non-response from Japan. There's other examples that we could talk about, of course. So we'll be looking at those cases where the court expressly talks about questions and answers, but also trying to identify cases where questions don't seem to have made any difference whatsoever. What were they doing there? Or maybe cases where the question and the answer didn't really assist the court, but maybe played into an individual judge's particular interests or agenda. We might see discussion about the question and answer in a separate opinion, but not in the judgment itself. And then there are also, we have an interest, I suppose, in identifying those cases where questions weren't asked, but maybe they should have been. Maybe it would have been useful for a judge to have asked a question, or maybe the right question wasn't asked. So these are all further avenues that we hope to explore. So I'll turn it back over to Cecily for our conclusion.
Yeah. Just a few concluding remarks. I think it's important for me to conclude by emphasizing this, that our project is at least partly empirical in character, and that we're not approaching this with a normative agenda, with the argument, for instance, that more questions would be good or desirable. Although our intuition, our starting point is that maybe more questions would be useful from the bench, but we're open to a different answer at the end based on the data that we've gathered. Now, we think also that the answers to these questions about the role that questions are playing from the bench relates to broader questions about the role of the court, the function of the bench. Now, from one point of view, it's not for the court through questioning to remedy defects, shortcomings in one party's arguments or evidence by asking questions. But then on the other side, it can also be said that the court should use all the tools that are available to it in order to ensure that it can adjudicate a case on the basis of the best possible information. And so that's how we'll be taking it forward. And we look forward to any questions or comments that you might have.
That was great. Thank you so much, both. And I look forward to see how this might connect to Janina's presentation later on that I prepared. For the next paper, we have Dr. Cecily from Radbound University, and assistant professor in international European law, and Dr. Muller, and also an assistant professor of public international law at Maastricht University. And they will be telling us about the rebels in the room and the role of individual opinions in the development of community interests at the ICJ.
Thank you very much. I will jump straight in, since it's always a struggle meeting the 15-minute limit when you have two people. Congratulations to the first two presenters who did that very well. So we're talking about the engagement, the contribution of individual opinions of judges at the ICJ to the development of community interest concepts. I think many of us, when kind of presented with this topic, have an intuitive feeling that there is an interaction, that there is a contribution from individual opinions to the development of community interest concepts. But what we wanted to do with this paper was to look into that in a bit more detail, to categorize the ways in which separate opinions do that, and to be able to see maybe a bit further what the impact of that is within the ICJ and in the context of community interest. Very briefly, I'm going to very briefly mention the kind of background information, a bit about individual judicial opinions and international law before the ICJ. Then I will speak a bit about the contribution of individual judicial opinions in the context of community interest concepts. And then I will hand over to Wim, my co-author, to give a bit more of a critical perspective on the impact of individual judicial opinions in this context. So first up, as many of you will know, and the legal basis of individual judicial opinions can be found in both the ICJ statute and the rules of court. There are some differing opinions between judges on the scope and the purpose of individual judicial opinions, but as we've seen in practice, that the individual judges have a large freedom to make statements on both aspects of the majority judgment, but also going sometimes beyond that. I want to speak very briefly about the impact and authority of individual judicial opinions. It's very difficult to really measure the impact of individual judicial opinions, partly because they are rarely referred to by the court itself in later judgments. They are, however, often referred to by parties, and they are often referred to in scholarship. And so we do kind of generally accept that there is a certain authority to individual judicial opinions. Part of that authority comes from the individual qualification of the judge in question. Part of that comes from the fact that the judge in question was present, so a kind of authority based on the fact that they saw materials to the case, they were acting in their capacity as a judge on that particular case. And part of it obviously comes from the persuasive authority of the reasoning within the individual opinion itself. I have here persuasive authority in context, because the context does seem to, or has been theorized at least to matter, in the sense that where there is, for example, a split in the majority, or where something has been rarely raised before international adjudication before, then the contribution of an individual opinion is often taken to have a stronger impact, a stronger authority in those particular contexts. So where there is a lacking consensus on that point of international law. Community interest we understand broadly, and when we talk about community interest concepts, we are talking about a few different things. So one, the conceptualization and identification of the international community as such, the notion of community interest as connected to that international community, and the expression of that interest through particular norms, most notably obligations erga omnes and peremptory norms or jus cogens. We identify 5 kind of categories of engagement or involvement where individual opinions contribute towards the development of community interest concepts. First, the underlying notion of community. So a good example of this is Judge Alvarez, who between 1949 and 1954 made at least 6 individual opinions in only 5 years, emphasizing what he called the new international law and the communitarist nature of the new international law. And these kind of early vision, or this early vision of Alvarez as expressed in these opinions, can be seen to really mark almost a paradigmatic shift away from what he calls the old individualistic law to an international law that is based on this notion of community that might therefore have, that might then have its own legal consequences. We also see in individual judicial opinions the recognition of particular community interests. So to highlight a few that have been identified by different judges throughout the years, we have the freedom of the high seas, legal certainty, international commerce, diplomatic privileges and immunities, environmental protections, and rules and principles of international humanitarian law. So this is quite a specific way in which individual opinions can highlight particular rules of international law or particular principles or interests more broadly construed that fall within this concept of community interest. Next, we have what we term the placeholder function. So it may, you can maybe say as perhaps an understatement that the ICJ as a majority can make conservative decisions at times. And when this happens, if an individual opinion is marks dissent from that majority opinion, it can act as a placeholder in that it presents an alternative route that can later be returned to. So a different route that can be returned to in the reasoning of a later decision. So to give an example of this, there have been several cases where in relation to the community interest, but a rather conservative, or one might call conservative, position has been taken in relation to the distinction between substance and procedure in community interest cases. So I'm thinking, for example, the relationship between substance and procedure in the application of the monetary gold rule in East Timor, or immunities and jurisdictional immunities of the state. And particularly what I wanted to focus on is the relationship between substance and procedure in compromissory clauses. So in the armed activities case, it was held by the majority that a reservation to a compromissory clause, to the compromissory clause in the Genocide Convention was valid regardless of any community interest in the Genocide Convention and the prohibition of genocide more generally. But then quite recently, but then there were several judges that made separate opinions dissenting on that point. More recently, in the Sudan versus UAE case, the parties, or Sudan in particular, referred back to that dissenting opinion as a basis for its arguments that the court should come to a different decision on a very similar point, so on a reservation to the compromissory clause in the Genocide Convention. And Judge Sima in the Sudan versus UAE said that the dissent of several judges, himself included, in the armed activities case meant that it was not self-evident that the reservation to the Genocide Convention in the Sudan versus UAE case was valid, and therefore that the lack of jurisdiction in that case could not be said to be manifest. Obviously, those arguments were not ultimately successful in Sudan versus UAE, but from Sudan's perspective at least. But I think it illustrates this potential of a placeholder function for individual opinions. Very briefly then, it also can serve a gap-filling function. So where the ICJ majority avoids a particular topic, then individual opinions can sometimes fill in. So to give an example here, if we think of Cansado Trindades' individual opinion in the whaling case, which highlights so in the whaling case, the ICJ didn't consider the question of whether Australia had standing as a non-injured state, because it wasn't raised by Japan, but it was raised within the separate opinion of Cansado Trindade, and that opinion is often referred back to as evidence of the whaling case as an example of non-injured party standing. Finally, individual opinions can also highlight areas for development. So, for example, in the Nikiforos case, Vice President Weeramantri's separate opinion highlights the need for new procedural rules that better reflect and that can better represent broader interests in inter-parties dispute that aren't purely bilateral. And so in that sense, it highlights the need for development within international law along the lines of community interest. And with that, I will hand over to co-author.
Thank you very much, Sally. Well, the heading of my contribution is still that I'm going to offer a critical perspective to separate opinions, but I think maybe it will not be so much critical as that I'm trying to contextualize it. But the perspective is kind of informed also to an extent by critical legal studies, I suppose. And because what we have noticed is that in a lot of the opinions that have just been discussed by Sally, maybe with the exceptions of the one from art activities, were products of judges who are not from the West or from North America or Europe, but rather from outside of what can be seen as the center of international law. So one of the things that we have been looking at is whether maybe the promotion of community interest can be seen as an expression of regionalism in international law. So the question then to ask is, well, are they simply expressions then of regional perspectives, or are they maybe, can you see them as assertions from the periphery that is trying to promote something like a community interest against the powerful center? Or are we looking maybe more at a more linear model of the development of the international legal system, such as, for example, promoted in the 1960s by Wolfgang Friedman, about an international law that's evolving from a law of coexistence to cooperation, and then possibly something like community. That can also be linked to some developments which you have seen in doctrine, which have been looking at international law from outside the Western world in a particular way, such as the 12 or the third world approaches to international law, but also some ways which have been explored, for example, by Shenho Yi, a Chinese international lawyer who spoke about law of co-progressiveness, or a Japanese lawyer called Onuma Yasuaki, the late Onuma Yasuaki, who promoted some form of trans-civilizational international law. And of course, also linked to 12, we have the approach of the international law from below, or a law that is promoted from the bottom up, as the book by Balakrishnan Rajagopal is called, in which we're also talking about notions that are promoted and that make their way through the international legal system and end up on the bench, but maybe not with judges who come from the traditional center of international law, but rather from without. So that would raise the question whether or not, get to that one in a moment, the promotion of a form of community interests is really expressive of regional interests or regional perspectives, or whether, it is something else. A contrary point that you could make is, and that's something that's particularly prominent in for example, the third world approach to international law, is that they, rather than emphasize community interests, they also they often promote sovereignty as a bulwark against encroachment by hegemonic powers, and that's actually kind of like an opposite approach in which an emphasis on sovereign equality is used to defend states against international law overreaching. Now, in that sense, you could also say that that is more present with states which have more power. And one of the things to explore then is whether or not having more power leads to more positivism, where positivism is defined as a more conservative approach to what the law says and what it does, and not trying to develop it too much, which would actually be a development that stands in the way of developing community interests. So that can be a counterexample, and we can, for example, earlier there was discussion, for example, of the separate opinions of the Chinese judge, who's not from the traditional center, but China is obviously a powerful state. So one question that we could ask is, well, is the promotion of community interests more something that states with less power do in order to contribute to an overarching legal system, but once they might obtain power, they would be more protective of their sovereignty and rather switch to protecting sovereignty instead, and be less in favor of the promotion of community interests. Now, if we looked at the individual opinions that we have examined, obviously one very strong proponent of a regional approach is Judge Alvarez, as described by Cecily, who also was very much an explicit promoter of a Latin American approach to international law, and that also led, of course, to the recognition of the existence of regional custom in asylum cases. But if we look at the judges from not from the West, but who have written extensive separate opinions elsewhere, often they are writing about community interests, but not specifically identifying it as coming from a regional approach. For example, Judge Gonzalo Trinidad was mainly writing from his own naturalist conception of international law, but without necessarily relating it to a Latin American perspective. So that is basically part of the critical reflection that we're still engaged in, and I think that automatically brings us also to the question that we want to give back to the audience, and something that we can discuss, whether or not this is a valid way of looking at these separate opinions, or whether in our reflection we should take a different path. So thank you very much for it.
This was great. Thank you so much. And now the next presenter, Nikiforos Panagis, is a legal officer at the International Tribunal of the Law of the Sea, and previously an associate legal officer at the International Court of Justice. And he will be speaking to us about arts in legal argument at the International Court of Justice.
Thanks. Thanks, Eleni. And thanks to James, to Christian, for inviting me. I'm really happy to be here. I should say at the outset, of course, give the usual disclaimer that whatever I say should not be attributable to the International Tribunal for the Law of the Sea. And of course, having said this, this is almost a redundant disclaimer in this context because I will not be discussing law very much at all indeed. Because as you'll see, what I'm interested in this project is to see basically how art is used and for the purpose of this presentation, I'll be focusing on counsel in oral pleadings. So I'm trying to see when and how and for what purpose they invoke art in their legal argument, not so much in their evidence. As I soon realized, and I'm sure you'll soon realize yourself, this is not so much a juridical exercise, so you can think of it more like as an intermezzo to get us kind of through the afternoon hump. And I suppose this makes me the court jester. In the next few minutes, what I will try to do is discuss briefly about the forms of art and the genres that are being invoked by counsel and pleadings, and then move to sketch out what I see as three different but potentially overlapping functions that art can serve in oral pleadings. And I should also say that, well, as I said already, it's pretty much a work in progress, but it's also, in terms of methodology, is a bit haphazard and impressionistic. But the pattern is I think, there. In terms of forms, as you would expect, the written word is the most predominant one. Law and literature have the word in common, so you will see loads of references to prose, poetry, drama. Even when you see references to songs, it's usually for the lyrics rather than for the music, for example. So the Bob Dylans and the Leonard Cohens are used as essentially as poems. In terms, there are a few references to visual arts, much less to performing arts. In terms of genres, there is a bit of more variety, but still what I find interesting is that there is an implicit and often overt kind of hierarchy, at least among some counsel, as to the better, the nobler art compared to others. So, for example, there was this one case where the mark and delimitation case, and counsel for one country basically likened the opponent to Winnie the Pooh, gluttonous bear who, when asked, wants both the condensed milk and honey on his bread. Similarly, the other state wanted both these and the continental shelf. And this is funny because it caused the indignation of the opposing country counsel. It might have been fine if we had references to Shakespeare, Dostoevsky, but Winnie the Pooh, this is far beyond this, or it should be at least. And more broadly, you see when counsel wants to praise the opponent, of course, with some sort of always kind of a sting at the end, they would liken their pleadings to kind of the Rembrandts or the Vermeers, maybe. Whereas when they want to dismiss them, it's surrealism, it's Dali, it's that sort of pleading, or that sort of art that they invoke. Now, the next thing that I would like to kind of move on to now is the function of art in pleadings. And the first and perhaps the most obvious one is embroidery. Hearings can be long. We heard that there can be several sittings for the same case. They could be like a week long, and if you're unlucky, they could be even longer. 6 hours a day. The Great Hall of Justice is a stuffy room. The roads are heavy. Reference here and there to art can go a long way to kind of lighten the mood and avert the risk of judges drifting off to sleep. And effectively, most of the examples that I have given already are of the embroidery type. But there is at least an additional function that art can perform, and this has to do with the explanatory power of art. So in some cases, references to art basically carry the argument over. So, for example, we can take painting by Magritte, The Treasury of Images, which is one of the Council's favorite. So yeah, it's referred loads of times, and I think the appeal of this painting lies in the fact that we could agree that there is something deeper philosophical meaning behind it. Now, what is more interesting, I think, is that Council tends not to agree on what that deeper philosophical meaning is. So you see the same painting being invoked both to say that sometimes we refuse to see the obvious, so we are basically deceived by the label underneath, and we don't see that this is indeed a pipe that we're looking at, but also for essentially the opposite the opposite point, that, well, this is not really a point. So whatever argument the other party is making is not really the case, even though it quacks like a duck and walks like a duck, it's not really a duck. And well, another example of a similar nature is, and this might be the Council's favorite, the reference to Humpty Dumpty, a character from Alice in Wonderland, and apologies for the long quote. But this is effectively the character in Alice in Wonderland, the children's book by Lewis Carroll, that basically says, yeah, when I use a word, it means what I say it means. So that's the character that unilaterally and arbitrarily, perhaps, ascribes meanings to words. So this, again, is used to make the point that the adversary cannot just unilaterally ascribe a meaning without further. Now, of course, one could argue that these are just examples of the first sort. This is embroidery, it's just wittier, right? It's just crisper, it's just better, maybe. But for example, we can find cases, and this goes back to the Temple of Peravihar, the original one, from the preliminary objections phase, where the part of the case, at least, turned on the interpretation of Thailand's optional clause declaration, the 36.2. So Thailand had made a declaration under the PCIJ, and it had renewed it under the ICJ. So now it was basically claiming, Thailand, that, well, you can only renew something that survives. If something has died and something has lapsed, you cannot renew it. And because the PCIJ dissolved effectively, with its demise, it took with it all declarations. So Thailand could not have possibly renewed the declaration of the PCIJ. And Council for Cambodia took basically the court by the hand through a journey from Horace to Shakespeare, using examples of where renew is used in the sense that you revive something that may have died already. And of course, we can perhaps say that this is effectively using art as an alternative to a dictionary, and often, I mean, possibly a more authoritative one, or at the very least, a more interesting one. But so here, art is basically used to buttress, if not to make the argument, at least to carry it and to support it. But I would argue there is a third function as well that art can be used for, and here art would be used not simply to explain a point, but perhaps to expand it, to expand the frame of reference beyond law, and to effectively make some cracks between in the four walls of the Great Hall, and let other considerations of politics, history, morality to kind of permeate and slip through and give the broader context, basically, of the case. So take, for example, the way that Ghana finished its pleadings in the recent proceedings on climate change. So these are a few lines from a poem by Ken Saro-Wiwa on basically the effects of environmental degradation. And what's important is precisely the context of the poet himself. So he was an environmental activist, frequently arrested, prosecuted, and eventually executed for the activism, for his activism in the southern Nigeria against oil extraction. So here, art is used as the medium to bring considerations that might otherwise be more difficult to bring in, and it does so in a powerful way. And in fact, it doesn't only bring in considerations in the courts, but potentially does the opposite as well. So it carries the message or the argument made by counsel Ghana in this case in the courtroom to the outside world. So here, the constituency of counsel is not just the 15 or 17 judges, it's a wider constituency outside of the court that would not be interested or willing to understand and to follow the legal jargon and everything, but this carries a more powerful message. And I think Alison mentioned how the wider public could be interested in that sort of these sort of moments in oral proceedings and follow them much more than others. And of course, there are other examples of that. So that's how the League of Arab States finished their pleadings in the Palestine opinion, not the pending one, of course, the one last year, a poem by a Palestinian poet. And there are more examples. I won't bore you with that from nuclear weapons. And in fact, I'll just put a thought out there, and perhaps we can discuss in the Q&A. Here, references to art veer very closely to evidence. So one wonders to what extent is this different from witness testimony that would be subjected to the rules of procedure of bringing new evidence, and to what extent is that a document readily available that one can refer to during the hearings. So where did this all leave us? Well, I'm not quite sure. Overall, I would say, yeah, that in terms of forms and genre, you see references to art, the ones that you would expect, like the more classical art, being kind of having the dominant role. But in terms of functions, I think art has at least the potential of breaking down some points and relaying it in a very powerful and effective way, both into the courtroom and outside of it. So it can have an expansive function as well, which of course carries with it risks of potentially manipulation, precisely because it's condensed in such a way. But for the most part, references to art are neither explanatory nor expansive. They're basically just embroidery. And perhaps sometimes an artistic reference is just an artistic reference. Thanks.
Right, that was great. I mean, I don't know, I kind of, having read the abstract in advance, that when this morning Alison mentioned how Judge Crawford talked about Athena springing off, self-determination as Athena springing off fully formed, kind of reminded me of Nikiforos's presentation. A myth is a story, after all. And from how we tell stories, we're going to go to Dr. Janina Barkholdt, a postdoctoral researcher at Freie Universität Berlin, and also formerly an associate legal officer at the ICJ, who is going to talk to us about those stories and the right to be heard at the ICJ.
Yes, thank you so much, Eleni, for the kind introduction, and good afternoon also from my side. Please allow me to thank, first of all, the organizers for inviting me. It's truly a pleasure to be here and to be part of this panel. In the next 15 minutes, I would like to address the role of the right to be heard in proceedings before the ICJ. So, unfortunately, much more boring than what we just heard from Nikiforos. And perhaps I could start by saying that to date, the right to be heard has rarely been referenced in explicit terms by the ICJ. However, I think that there are at least 3 reasons why this right deserves closer attention on the occasion of the court's 80th anniversary. So first of all, I have the impression that it plays an important role in practice. So if we look at parties and participants before the ICJ, they frequently invoke the right to be heard to advance their procedural objectives. So on the one hand, they do so in support of their own procedural requests, for example, for the extension of time or page limits, or even for permission to intervene in a case. And on the other hand, they also refer to the right to be heard to oppose the procedural requests by the other side. For example, by arguing that if the court were to grant those, it would leave the party without sufficient access to information, time and space to present their case. Beyond the parties and participants to a case, also judges frequently refer to the right to be heard in their separate opinions. So, for example, in the recent Sudan versus UAE case that Sally and Wim were referring to, judges were claiming that Sudan's right to be heard was infringed by the court's procedural approach in that case. And if we look at a couple of separate opinions, the right to be heard features quite frequently there. Secondly, despite these references to the right to be heard by parties, participants, and also by judges, they do not always seem to share a similar understanding what that right actually entails. And this is in particular clear, I think, with respect to the link between the right to be heard and the right to be heard orally. So does the right to be heard actually entails a right to be heard orally? Another source of confusion, I think, stems from the term right. What does the right to be heard actually mean? What sort of rights are given to the parties by invoking it? And then also, what are the legal consequences if the parties fear that their right to be heard has been infringed by the court? So given that the right to be heard's content, scope, and limitations remain unclear today, I think this is worth having a closer look at it. And finally, thirdly, I believe that the significance of this right is growing, in particular as the court faces an expanded caseload and also serves as a venue for that so-called strategic litigation. And in this context, I think that a closer examination of the scope of such a right and also of its limitations is essential to clarify not only its role as a procedural safeguard, but also preventing that it is essentially being reduced to a strategic tool or even to become a stumbling block in the court's efforts to adapt its procedure to those developments. So for these 3 reasons, I started working on this topic, which is, I should say at the outset, work in progress. And given that we cannot really cover all the interesting issues arising in that context, I would like to focus here on the implications of the right to be heard for oral proceedings. Before doing that, however, I would like to briefly make a few general remarks on what I understand as the legal basis, content, scope, and limitations of the right to be heard. So just very briefly, first of all, is there a right to be heard applicable in proceedings before the ICJ? So if we look at the text of the statute and the court, there is no explicit reference to it. and also in comparison to other unwritten procedural rules or principles. For example, the sound administration of justice, there are relatively few references by the court. And wherever the court is referring to the idea behind what is usually understood to essentially flesh out the right to be heard, the court uses different terminology. So, for example, there's just one decision by a chamber where it's actually called right to be heard, but there are other decisions where the court is, for example, referring to the principle audi alteram partem or the maxim audi alteram partem. And in other cases, the court simply derives this idea from more broader principles, for example, procedural fairness or the sound administration of justice or equality of the parties. But I think, irrespective of that terminology, I think what emerges from the case law is, first of all, that there is a distinct principle or right to be heard, and secondly, that principle has a separate and independent legal basis. And I would argue that this is a general principle of law under Article 38(1)(c) of the ICJ statute. So then, secondly, what is actually the content of that right to be heard, and what sort of right is conferred to the parties? Having undertaken a first comparative analysis of the right to be heard as understood in municipal legal systems and the international various international legal instruments, I think that their common denominator would be that the right to be heard requires that each party or participant in a given case is given a meaningful opportunity to present their arguments and also to have those arguments duly considered by the court before it renders its decision. Now, here I think two aspects should be emphasized. So first of all, I would argue that a meaningful opportunity differs from an equal opportunity. So in that sense, it overlaps, but also goes beyond the equality of the parties. And then secondly, I think that the use of the term right in right to be heard is somewhat misleading. I do not think that it creates a self-standing right for the parties, but I think nevertheless it does have a highly important practical relevance. For example, it underlies and reinforces existing specific rights contained in the statute and in the rules of court. And it also has direct implications for the court's decision. So, for example, in the ITLOS case, the court actually said that it could not decide on a specific point because the parties had not been heard fully on that point. And finally, it governs the way in which the court manages specific cases and also amends the rules of court. So this brings me to the scope of the right to be heard. Of course, the right to be heard cannot be absolute. It's limited by other procedure principles, and notably the power of the court to organize its proceedings under Article 48 and 54 of the ICJ statute in the interest of judicial economy and the sound administration of justice. And this is also why I think it's important to have a closer look at the right to be heard, because I think the more precise we define it, or precisely we define it, the more persuasive is any balancing exercise between the right to be heard on the one hand and the sound administration of justice or judicial economy on the other. And by that, I think it also protects the court from accusations of inconsistent or even arbitrary practices in respecting the right to be heard. So this brings me to the second part of my presentation. I think there are many situations in which this tension between the right to be heard and other procedural principles arises, including, of course, the written proceedings. However, I would like to focus here on the oral proceedings. And in brief, what I would like to argue is that the right to be heard should be clearly distinguished from the right to have oral proceedings. However, I think that the right to be heard has implications both for the question whether to hold oral proceedings and for the how of those oral proceedings, so how those oral proceedings are conducted. Turning first to the question to what extent the right to be heard might entail a right to be heard orally. We could argue that there's no relationship between those two because, after all, a meaningful opportunity to present arguments can also be granted by way of written proceedings. Looking then briefly at the role of oral proceedings, and that doing that on the basis of the statute and the rules of court, we see that the statute does not contain a requirement for oral proceedings in all decisions. Effectively, there's only Article 43 that prescribes oral proceedings. And if we look at the rules of court, we see that there's a great variety of the way how the term "here" is being used. So there are essentially 4 types of interpretations given to the word "here," or how the parties are heard. So in some instances, the rules of court go beyond the statute and prescribe oral proceedings. In others, the court is given discretion whether or not to hold oral proceedings. In some instances, and this was also criticized by Judge Lauterpacht in the 1997 Bosnian genocide case, sometimes the rules of court are simply using the term "here" without specifying whether this should be done in written or in an oral form. And the court has consistently interpreted it as meaning writing. But then there are also those cases where this is inconsistent. And here we see in recent years a certain development by the court to shift more towards a written procedure and reduce the form of having oral proceedings, sometimes also reducing simply the length or the rounds of oral proceedings. And we also see that in the modifications of the rules of court, where, for example, with respect to interventions under 63, the court now retains a sort of discretion whether or not to give interveners an oral proceeding or the possibility of intervening in the oral proceedings. And so coming back now to the right to be heard, does the right to be heard in those instances influence the way how the court should make use of its discretion? First of all, I would like to say that I do not think that there is generally a right under the right to be heard to have oral proceedings, but I think everything depends on how you interpret meaningful opportunity in a given case. And here I think what is crucial is how the word or how a meaningful opportunity has been defined by the parties to the statute and how it has been interpreted also by the court. So, for example, with respect to Article 43, it's clear that in contentious cases to the merits, parties understand oral proceedings to form part of a meaningful opportunity to present their case. I would argue that this also applies to decisions that have a very similar effect to decisions on the merits in contentious cases, for example, preliminary objections. Secondly, I also think that where the court is creating procedural expectations, for example, to oral proceedings to have oral proceedings in certain incidental proceedings, that's also creating the impression that this is important for having a meaningful opportunity to present the case. So to conclude the whether to have oral proceedings part, I think it might be good for the court to perhaps clarify what "here" means in the rules of court directly, as was also back then asked by Judge Lauterpacht, or at least to be consistent in the way how it understands "here." Turning then to the how and the implications of the right to be heard for the how, I actually think that the right to be heard is much more important for this particular aspect of the oral proceedings, because here we see that it can influence the time granted to prepare oral rounds, the length of the oral rounds, also their number, and the intervals between them. I think that a very restrictive approach here can come in conflict with the right to be heard. And a possible solution, in my view, here would be to allow or institutionalize a second round in writing after, for example, having single round hearings, to allow parties to respond to what has been argued in those first rounds of hearings. And here I think that perhaps either a consistent practice of the court under 48 of the statute would provide a way forward, or even an expansion of Article 72 of the Rules of Court, or maybe even a separate provision that provides for an institutionalized form of that. That could, for example, also be combined with questions posed to the parties and the responses, as was just talked about by Mike and Cecily. So in conclusion, I argue that that it is important to understand the right to be heard as a distinct procedural guarantee that is applicable in proceedings before the ICJ. It requires the court to interpret the statute and the rules of court in a way that affords each party and participant a meaningful, not only equal, but meaningful opportunity to present their arguments. This entitlement, however, does not, or this right does not confer an entitlement to have oral proceedings per se, but mainly influences the way how those hearings are, oral proceedings are conducted. And I would propose those two measures. On the one hand, clarifying the meaning of the word here, and then secondly, to institutionalize some sort of second round in writing where the court decides to proceed in single round oral proceedings. Thank you very much. I'm looking forward to the discussion.
Right, that was really great. Thank you so much all for keeping the time. And we have about 15 minutes for questions or so. I will take first round of questions and then we'll see where we go from there. Oh, right, okay.
I'm Francesco Sindico, University of Strathclyde Law School. Two questions. The first on the questions that are being posed to the court. In the climate change advisory opinion, those in my opinion were very powerful, especially the one on fossil fuels. And the one thing I did see, I wonder whether you see it as well, that in this specific advisory opinion, the court actually refers to the question. So it doesn't really leave much to doubt as to whether they were impactful or not. So that's my question to you, whether you've seen it elsewhere. And in terms of art, again, in relation to the climate change advisory opinion, not surprisingly, considering the amount of new countries before the court, it wasn't so much these Western beautiful paintings. It was indigenous knowledge, like the story of Helena for St. Lucia. I wonder whether you have looked into it and whether it says something different. Thank you.
I have a question here.
Sorry. I'm from University of Oxford. So I just have a question for Cecily and Mike, and it's a slightly odd one. But my sort of immediate reaction to a presentation was, well, maybe, you know, as legal researchers in international law, we should all be doing our due diligence and actually going through the record of oral proceedings, you know, with a particular view to questions and their answers, you know, as part of kind of just the exercise of legal research. And I just wondered whether that is something that you see as kind of a takeaway from the work that you've put in, because my impression so far is that scholarship will sometimes cite oral proceedings and it's always seen as kind of a nice extra effort, but it's not really seen as necessary. And I just wonder whether this is something that you would now sort of advocate based on the work that you've done.
Great, thank you. My name is Millicent Mudiwa with University of Aberdeen. My question would be going to Sarah, William, and Michael, as well as Cecily. So from both your presentations, one could deduct that separate dissenting opinions can sometimes influence international legal development, correct? My question would be, do you think that they undermine the unity or authority of the court? And to be precise, I'd like to give an example of one of the judges, Judge Sabatinde from Uganda, given her previous remarks officially and the ones that she made on an official news channel while she was in Uganda, where she was claiming that the Lord is counting on me, something like that, which many scholars did think was quite not as professional. Excuse my comment. Yeah, thank you.
One last question on this round and then.
Hi, Sarah Wisman, University of Salzburg. I have questions to Nikiforos and Janina. Nikiforos first. I think from a methodological perspective, you weren't quite, you raised a methodological question, how you would tackle it. And I read a very intriguing paper by Gregory Messenger. He used more of a Bourdieusian approach to analyzing how counsel used language in front of the court, not only language, but also their attire. And if you want to, I'll pass it on later to you, and then you can have a look at that, because I found it quite interesting. And then my actual question relates to what has been raised before. I was wondering whether you also observed how non-Western judges responded to these artful interventions within pleadings before the court, because you mentioned, and also the previous commentator here mentioned, that recently art interventions have become more inclusive in terms of also non-Western arts, but they haven't been in the past, and still I would say that predominantly Western arts are mentioned in front of the courts. So I wondered whether that had an exclusionary effect on the judges and whether that alienated them a little bit. And then to Janina, you mentioned that you see the right to be heard as a general principle of law. So I assume that you're speaking in terms of foro domestico, because you mentioned that you reviewed municipal systems. I think it's debatable whether it is a general principle, but I found it quite interesting because my first thoughts went to the UNDRIP, for example, so the Declaration on the Rights of Indigenous Peoples, and the question, and how far do they need to be heard in matters that affect them? We saw that in the Namibia and Germany negotiations. So if you see it as a general principle of law, then we have this two-step methodology, of course, and I wondered whether at the transposition level then, you would maybe see human rights also, entering the spectrum and how far the right to be heard then is transposed on the international level in terms of UNDRIP and other human rights that might come into play. Thank you.
Okay, thank you so much, Sarah, for that question. I would indeed argue that you can derive the right to be heard from municipal legal systems in the first step, the comparative analysis step. And then the whole question is to what extent can you transpose it to the international level? And since I was focusing on proceedings before the ICJ, I was mainly looking at the rather difficult question to what extent you can actually transpose the right to be heard that is usually applicable to individuals in domestic legal systems to the relationship between states. Also, and this is, I say it's difficult because very often we find it linked with the dignity of the human person. And then the question is to what extent can you actually transpose that to states? I would argue that you can transpose it still to the international legal system because you can, to some extent, modify it to make it adaptable to the international legal system. And you also see that states have actually accepted the right to this was a cliffhanger. So I was saying, I think that in my view, you find enough evidence that states would accept its application also in interstate relations, because you find, for example, references to the right to be heard in various arbitration instruments. So, for example, in the PCA rules of 2012, you find a reference to the right to be heard and also a definition that comes very close to what I was just saying. So I think you have enough evidence for its transposability, so to say, to the interstate relationship. With respect to individuals and indigenous people, I would argue that probably the argument is even stronger to say that the right to be heard is a general principle applicable between individuals or concerning individuals at the international level. The question is just then in which proceedings, probably in regional human rights courts, to the extent that they have standing, of course. I don't think that you can invoke the right to be heard to overcome jurisdictional or admissibility hurdles. Yeah.
Thanks. Thanks for the questions. To take Francesco's question first, I think you're right that advisory proceedings lend themselves to broader kind of range of voices. I haven't looked so much at the stories of indigenous peoples, for instance, in the climate change. The reason being that that there may be a thin line there between use of art and use of witness testimony or evidence, right? So, and of course, the line is thin, and the nuclear weapons advisory opinions citation that I had there shows this, because it was evidence. It was basically a poem by a survivor of the nuclear bomb, and it's a poem, so it's art technically, but at the same time, it's evidence, right? And you can see the same also in contentious proceedings, like in the Nauru case, where you had photographs, basically, of the phosphate land and the mining. So there is a thin line there, but I tried, at least for now, to limit myself to more what's the word? I suppose more obvious instances of art, as opposed to what could be witness testimony, if that makes sense. And this, I suppose, brings me also to Sarah's question. Thanks again. I'm not sure, at least I'm not in a position to say whether non-Western art is being referred to more frequently in recent years as opposed to previous years. I would guess and venture to guess that this has to do with the advisory nature of the proceedings or not, and this in turn is just presumably or possibly just a reflection of the fact that in advisory proceedings, counsel themselves may come from the countries, so they would be more familiar. Basically, the references, I would think, from a sociological perspective, would just be a reflection of where the counsel themselves come from, right? So in advisory proceedings, it's more likely that you would have stories from a non-Western perspective. Now, in terms of judges' opinions, that's also like where my research is very much a work in progress. I don't think it's easy to find a correlation, like in terms of how judges respond to references to art, not least because these references to art are not that important in the grand scheme of things for the proceedings. But what I could say is that you see sometimes non-Western judges relying on and referring to Western art, and again, possibly because that's the canon. So the opinion by Judge Matri comes to mind. I think it was in Gapsiko Vanagimaros, where he makes the point about the protection of the environment, how important that is. And he lists, much like Dean Acheson in The Temple, he lists artwork from the Western canon to prove how Europe or Europeans have thought the environment to be important, its protection to be important. But I'm afraid at least for now, I have not much more at hand. And thanks also for the suggestion. Thanks.
Yeah, on whether separate opinions undermine the authority of the court. So I think there's two different ways of looking at this question. It depends a bit on what is meant by undermining authority. So I think the Sebutinde case is perhaps is rather exceptional, right? And I think when we talk about the potential of that particular case as undermining the authority of the court. It's more a question of have her comments. It's more a question of reputational cost, I think, and whether her comments have undermined the trust that we have in the qualification of judges and in their impartiality. So I guess, yeah, in that sense, it is, as I said, a kind of exceptional question as to whether that happens. And I think that hasn't, yeah, I don't want to make any definitive comments on whether that is that has actually happened. But I think that is more a question of reputational cost rather than a tension between a separate opinion or an individual opinion and the opinion of the majority. And that is more of a common discussion, right? That whether dissenting opinions are a challenge to the persuasiveness of the majority judgment. And that, I think you can kind of say that you see it in what or what we call the placeholder function. So presenting an alternative route for a future court to go down. In a sense, I don't know if I would quite use the word undermine, because I think that implies a greater authority or a greater force of precedent in the majority opinion to start with than it necessarily has, at least formally in international law. But certainly separate opinions can, when we say reduce the potential future impact of a majority decision by offering an alternative route. That I think is the contention in the placeholder function that we present in the paper, which is a separate type of, or a separate view of undermining authority to the question of sebutinde, if I can put it like that.
Okay. Well, actually, I think Sally formulated it much better than I could have. I agree with everything she said. I just wanted to add one thing, in the sense that my instinct would also be to say it's neither yes or no that separate opinions undermine the unity or authority of the courts, because I think you can also determine it more on a case-by-case basis, and even also expect judges to actually use them in a quite responsible way, because of course, they are also very mindful of the function of the court and that they can't undermine it too much. But in practice, you've seen that in some cases, separate opinions have actually had a mollifying effect on the impact of a judgment, or they have provided more explanation. For example, where the reasoning of the court was actually very sparse, and maybe it was unclear what it was based on, and then individual opinions might provide more insight in where things come from. And well, for example, if you look at the Marshall Islands case and Judge Crawford's opinion, I think he's actually the one who coined the term objective awareness, which is nowhere to be found in the judgment. So it actually clarifies the concept quite a bit, but there are many of those. And I agree that Judge Sebutinde, that case is quite special, but in a way, the fact that she made these comments and they came out, to me personally was a bit of a relief, because it actually showed that the poor reasoning and especially the way in which evidence had been dealt with in her separate opinions was suddenly much more understandable than if all that we would have had were those opinions. So, I guess that one is still going to play out. So.
I'm going to respond to Priya's question. So if I understood correctly about whether, as researchers, as part of our due diligence, we ought to be looking at oral proceedings. So my answer is, of course, yes, but I have a lot to say on the matter. So I think that sometimes a case, not always, but often a case can't really be fully understood without understanding how the parties argued their cases and what kind of evidence they put before the court. And of course, there's two ways to then develop that sense of how the case was argued. One would be to read the written pleadings, which are typically voluminous, and the other is to look at the transcripts of the oral hearings. And at the oral hearing stage, that's when the parties are really distilling their arguments. And they're shorter, much shorter than the written pleadings. So in a way, that's a shortcut, and I think a viable one for researchers. And I think that in looking at those oral transcripts, you can sometimes then develop an understanding of why the judgment reads the way it does, because sometimes judgments do read in a strange way, or in a way that makes you wonder why they approached it in a given way. And sometimes that really is a direct response to how it was argued. Maybe the argument was convoluted, or the state was pursuing a particular historical narrative that actually wasn't necessarily fully to its advantage in the case. Sometimes also there's an odd discrepancy between the way the case was argued and then the approach that the court ultimately takes, which isn't based on the parties' arguments. So I think it's really important. And also sometimes I see critique of the court that comes across as harsh if you don't then also look at how the case was argued, right? So sometimes it's true that a passage in the judgment or the approach will perhaps come across in a strange way, but it has to be understood in light of the argumentation. The only other thing I want to say is I think oral proceedings are not only important for researchers, but also for teachers. So I teach international dispute settlement, and I show my students clips of the hearings so that they develop at least a little bit of a sense of how the arguments are made, how the evidence is presented and discussed, and then also how little the judges engage directly with the counsel.
So I was going to answer Francisco's question so this was about the questions that were posed at the end of the oral proceedings in the climate change advisory case. So on the last day, there were 4 questions posed by 4 different judges. And those questions were, this was my thinking at the time, extraordinarily broad. They were really big questions. And my comment at the time, in fact, was that any one of these questions could itself have been the request for an advisory opinion. And so I actually think that this is problematic. On the one hand, it's good that judges decided to seek out the information that they needed, looking ahead to seeing how they thought the case was going to play out. They went out and sought that information from states. On the other hand, I don't think it's so great that they even needed to ask in this instance, because this was at the end of an extraordinarily long hearing. And the fact that such basic, core, fundamental questions had not yet been addressed in the proceedings, I think is problematic and actually goes to some of the inadequacies and deficiencies of the way advisory proceedings work, or at least the way advisory proceedings work when they're dealing with these very broad-ranging, sometimes technical, scientific-related questions. There was also a specific issue I had with this because parties were given a chance to, it was open to all the states that participated, and they had 1 week to respond. That to me was extraordinarily short. So this goes a little bit to Janina's argument, I think, an extraordinarily short amount of time to address 4 enormous questions. And the second problem with it was that normally in a contentious case, when there's a question from the bench at the end of the hearing, either to both parties or to one party, they can respond in writing, and then they have a chance to comment on each other's responses. And that opportunity wasn't afforded to states here. It was a one-off. So everyone could respond, but nobody could respond to whatever anyone else said. So while it was useful and that it gave the court more information, I don't think it was a great procedure. And the one last point I'll make about this is that in a lot of the literature about questions from the bench or should the bench be more active, people then turn to say, well, actually, wouldn't it be better if the court was more proactive and asked questions or directed parties in contentious cases too, indicated to them in advance of the oral hearing, these are things we'd like you to address. And the court does that very rarely, but in some of the literature over the last 10 years, we often see the discussion pivots from should there be more questions from the bench to this, should there be more questions in advance. I'm actually pretty skeptical of the court's ability to do that in a useful way in most cases, in contentious cases. And there's a reason for that, because certain states have the burden of proof. They have something they have to show. That's not the case necessarily in advisory proceedings. So I think there actually is a stronger argument for preliminary pre-hearing questions or direction from the court in advisory proceedings. And this might be a good example, the climate change case, where it might have been a good idea, given the huge broad-ranging nature of the question that came from the General Assembly, for the court to have been a little bit more proactive and directed party to some of these questions that ended up being asked then at the 11th hour. Thanks.
So I have the here.
Well, again, it's very tempting to ask all of the panel a question, but I will try to refrain from that. They were all very interesting. to pick up on what Michael has just said, and I agree with almost everything he said, as I always do. I think that questions from the bench there's also the cultural idea. It's often said that civil lawyers don't like asking questions because it reveals what you're thinking, which might mean you've made up your mind. Common lawyers like to be asked because if you've made up your mind, we want to know so that we can convince you to think otherwise. So there is a bit of a difference, but I don't detect any difference in who asks questions, in fact. So maybe that doesn't really apply. How are questions answered is perhaps something you should also be looking at. And you've touched on that with what you said about the advisory opinion questions, climate change. Questions are sometimes an opportunity for a kind of post-hearing brief, such as you get in investment cases. I'm totally against that. I like to forget about a case after the oral stage, but it is an opportunity and can be taken as an opportunity. Sometimes, however, the questions are so silly that you feel like being rude when you answer them. To give an example, in a case that's just finished, Judge Zimmer's question to the United Arab Emirates at the end of the genocide case, he said, "Why did you make a reservation to Article 9 of the Genocide Convention?" We were given, I think, about 6 hours to, no, 12 hours to answer, and the other side were given 6 hours to reply. But anyway, we didn't take us very long because we said we made a reservation because we didn't want to be bound by it. And it seemed pretty obvious to me. The other question that we got in that case is an example of what I would suggest is a judge trying to be helpful to one of the parties because that party has not argued its case as well as it should have done. And this was Judge Tonka, who very cleverly said, we've got 2 English translations of the UAE's reservation, and they say rather different things. Which of them are you relying on? The UN translation or your own translation that you've submitted to the court? And we haven't really thought about that. We said, well, actually, they're both clear in our view, but we're relying on our own reservation. I think often questions are trying to be helpful. But it would be interesting to know if a lot more questions are asked where there's an absent party. You then ask the party that is present a lot more questions. Or if a case hasn't been argued very well or isn't being argued very well. And I think of the Belgium-Senegal case, where Belgium was asked about 10 questions between the 2 rounds. And we have the weekend luckily to answer, but that was because the other side on that occasion hadn't actually been arguing the case very well. So the court was trying to be helpful to bring out arguments. Now I'd like to talk about everything, but I won't. Just on art, I think counsel are very self-indulgent when they start quoting Alice in Wonderland. It's often just a private joke between them and they think they're being very clever. I think there was more opportunity to do this when oral hearings lasted 5 weeks. Now that they last 2 hours each side, it's hopefully it's going to be reduced. I don't actually find it helpful. I can give you some examples, but I'll do that privately. Talking of hearings being very brief, I think for Janina, in provisional measures hearings, it's become so brief. There's only 1 round. It happens on the same day. This does not give an opportunity to the applicant to respond to what the respondent said. And I experienced that in the Mexico against Ecuador case, where actually I was acting for Ecuador, so I benefited from it. But I thought it was really unfair that Mexico speaks, Ecuador speaks, and that's that. And we had the same with UAE Sudan. That was all in 1 day. Unfair to both. Sudan didn't have time to think about what had just been said. Sorry, UAE didn't have time to think about what had just been said by Sudan, and Sudan didn't have an opportunity to reply. So I think by condensing the hearing so much, they are perhaps taking away the right to be heard.
Thank you very much. I have questions for Cecily and Mike and for Janina. So just for Cecily and Mike, in terms of the distribution of how you're distributing the frequency of the analysis in terms of going by presidency, for example, I just wondered how much individual cases skew the analysis over a 3-year period. So I just like to hear sort of more on that in terms of when you're trying to analyze how things have changed over time. You mentioned in your presentation, the Whaling case had a lot of questions that would, I would assume, skew the 3-year sort of the frequency per case in a 3-year analysis. So sort of how much variance is there over the course of cases? Perhaps maybe some explanations that you have or preliminary thoughts as to why that might be the case, what different kinds of cases might result in differences in the number of questions. And for Janina, just in terms of the idea of a meaningful opportunity to be heard, what I was thinking about there is just the purposes of appearing at oral hearings and the imagery of appearing at oral hearings, which is something that you'll see all over the LinkedIn pages and Twitter posts of states and foreign ministries, and also perhaps say of in the Ukraine-Russia allegations of genocide case, you have the imagery in the courtroom of all of the parties, the interveners who happen to be supporting Ukraine, sitting on the side of Ukraine in the courtroom, and nobody sitting behind Russia in the courtroom, as a political message. And whether or not you think that kind of political imagery or use of the court counts towards whether or not, or your understanding of what a meaningful opportunity to be heard is. If so, why? And perhaps if not, why not? Thank you.
Great, thank you so much. Before I take more questions, can I add one question to Cecily and Michael that goes towards what Joseph was asking there about the 3-year period? I was curious about, I find plausible the premise that the president has some sort of effect on how case is managed and how questions are asked. But I was wondering, were you starting with it in your mind, or did you come across this kind of like observation as you were researching? Was it something that came from your anecdotal knowledge of the court, or something that you had as a sort of like hunch that you pursued, or did you actually stumble upon it afterwards? Because I think that would make a difference in terms of like the kind of things you might have assumed, or the kind of things that you might have found spontaneously, I guess. And then there's the question. Yeah.
Thank you. My question follows up your observation, in fact, because you are taking the presidency as a term of reference in order to distill the frequency of questions. My only word of caution would be, I don't think that can be done, because otherwise you would be entering what Bejawi called le jardin des juges. You can't do that.
Could I ask you to clarify?
I think it's a question for clarifying what do you mean by you can't do that? Is it about the researcher or the president, right? So,
yes, because that's the secrecy of the interaction between the president and members of the court.
I just have 2 short questions. The first one is for Professor Becker and Professor Cecily Rose. And because you just mentioned about your research involve a quantitative and qualitative assessment of the questions. So I just would like to, if you could explain just a little bit how you really done this quantitative research. And because I remember Professor Cecily Rose just mentioned that you count up like up to 350 questions or something like that, because this number is quite daunting. So just wondering, curious how exactly this comes up to this number. What is the research method like this? And the second question is, I would like to ask Janina, and also follow up the comment just made by Sir Michael Wood, because I remember very well, like last year, at the end of that Cambridge conference, he also commented, because that time I think it was just like the Palestine, occupied Palestine territory advisory opinion oral proceedings. Then you mentioned something about the sequence of the participating states. And also, I think, for example, in the climate change case, there's such a big number of like participating states. And just as Professor Becker mentioned, that there was no second round of the states who gave the oral a statement later, maybe could have the better chance to argue their or respond to some issues. So maybe in this regard, how this kind of right to be heard can be more equal for every participating states. Thank you.
Right. Maybe we can go back to the panel and then we can possibly have a last round of questions.
Thank you so much for the questions and the comments. Perhaps starting in a chronological order with Sir Michael. I fully agree that the single round hearings, especially in provisional measures, are problematic from a right to be heard perspective. Can I ask you if, in your view, it would be remedied or healed if there were afterwards a written procedure for the second round in writing? Would that, okay. Then going to Joseph about the role of political imagery in affording a meaningful opportunity to present arguments. Of course, I'm not in a position to comment on any specific case that was considered back then, including the Ukraine-Russia ones. Apart from that, I would say political imagery does not as such play a role in having a meaningful opportunity to present one's case. Having said that, of course, to the extent that the statute or procedural expectations raised go into the direction of having oral proceedings, and that motivates the state's decision, for example, to bring a case. I think it plays a role, but political imagery as such, I don't think is relevant in this regard. To Xiaoyu, on advisory proceedings and how it could be organized in a more equal way. Of course, there is also the consideration of procedural economy and the sound administration of justice. So in that sense, it must be taken into account and balanced here with the right to be heard. I would say that there could be procedural mechanisms, for example, having a mix between oral and written proceedings, because for example, for advisory proceedings, the court has discretion whether to proceed in written or in an oral form. But once it decides for oral proceedings, one could, for example, consider grouping states or incentivize states to align or to team up in a sense. But yeah, it's a balancing exercise. The right to be heard cannot be completely taking, for example, as in Barcelona traction back in the days for several months.
Well, I don't think there were any questions for me, so I'll just pass it on. Thanking Sir Michael as when I have it.
I'll first take up Sir Michael's comments and questions. You began by noting the cultural difference or the difference in legal backgrounds among the judges. And indeed, we did actually begin this research project with perhaps the assumption or the intuition that common law judges might be more inclined to ask questions, and that's not what we've seen. So that's also interesting that we've discovered that another intuition proves not to be quite right. There was a question about the frequency of questions and whether the distribution ends up being skewed by particular cases in which there happen to be a lot of questions, and the answer is yes. So when you think of it, in any given 3-year period, when you have a given composition of the bench, there actually aren't that many hearings, right? So it means that in a given triennial period, if you have a couple of cases that result in a lot of questions for whatever reason, you have an uptick for that period. And this is the reason why we don't see a steady trend, right? And that's a finding in and of itself, that it just goes up and down, it varies over time. And I think that also, for me, was it showed how actually in many ways infrequently the court holds hearings. So I think the court is fully busy, but in terms of sheer number of days spent in oral hearings, it's much, much less compared to other courts. Finally, in terms of our research method, it was actually quite straightforward. So all you have to do is look at the oral transcripts for every case, and the president typically allows questions to be posed then at the end of all the hearings or at the end of the first round or both. And then each question then comes with a bunch of data surrounding it, including who posed it, etc. And I'll let Mike field some of the other questions now.
Great to get so many questions. Just to Sir Michael, I would say yes, I fully agree, some questions are silly and silly questions lead to silly answers. So we'll take that into account too, but many other good suggestions for the project. So on the reason for the 3-year period and kind of building off of what Cecily already said about how much does one case skew results. So for one, we are working with a statistician who can help us with some of this, figuring out the significance of some of these things. Although he hasn't helped us out that much yet. But that's why I mentioned very briefly in the presentation, we also have graphs similar to the ones I showed that break down the data by decade, because I was curious, would that eliminate some of that, very sharply zigzagging lines? And it does a little bit, but it doesn't show the kind of steady upward trajectory that we might have expected. It shows a bit of that, and then actually a pretty steep drop off in the last 8 years or so, which is interesting because that corresponds to when the court actually has been extremely busy. The last full triennial period, 2021 to 2024, featured more hearings than any other triennial period in the history of the court. So there you go. To the question then about the need to be a bit cautious about ascribing too much weight to who was the president at the time. I don't really see a problem with us taking that into account, though, because we're looking for correlations. We're not trying to kind of get into the black box of exactly what's happening in the deliberation room before judges enter the Great Hall. We're going to try to approach it from a data perspective and say, well, are there a lot more questions being posed, or greater frequency of questions when this person is president versus when that person is president? Now, of course, and the other factor there, to go to the question, a different question, was, yes, this is based a little bit on first of all, our personal experience, or we know that the president of the court functions as a kind of gatekeeper when it comes to judicial questions, and there will be discussion, an internal confidential discussion among the judges about whether a certain question should be posed or not, and the president has a certain authority on that question. And judges have written about this as well, so that's in the public domain. So we think we can look for these correlations, but of course we understand that that wouldn't be a complete or comprehensive answer to explain anything. You'd have to look as well. So if you see a given 3-year period where there were very few questions, and you say, well, that's because so-and-so was the president. No, I don't think we would go there, because you'd also need to then take into account, well, what types of cases happen to come up during that 3-year period of time? Maybe our data will show that those types of questions typically don't result in many questions, or who knows, there's lots of other factors. So I think it can be part of the puzzle, but it's not a complete answer, and we wouldn't claim that it's going to be a complete answer to the types of questions we're trying to ask.
Thank you. Thank you, everyone. Hope you can hear me. So my question is to Janina, and it's to follow up from the question of Joseph, but I had from a different perspective. So I don't think the point is the political imagery, but when you have intervention cases, and the case of mass intervention, and as you said, the rules were amended,
can you afford the same opportunity to the parties to be heard when you have many parties in the same cause? Though we know that the court in its jurisprudence has not recognized that you can have interveners in the same cause. From the whaling, these arguments have been posed for years by the parties opposing intervention that actually goes against them. And when you have more than one party intervening to the other side, how does that meaningfully affect the right to be heard? And whether your approach and whether the court's approach and the rules satisfy your requirement in that case.
Great. There was another question there. So.
Thanks. I have a question for Sally and Wim about methodology, basically. I was wondering, Article 57 of the ICJ statute mentions separate opinions, but we know that they can be different creatures. We can have like dissenting opinion, concurring/individual opinion, separate opinion, declaration also. I was wondering because like Sally mentioned actually the declaration of Judge ad hoc Sima in the recent Sudan versus United Arab Emirates cases. So I was wondering if you were able to spot any variations among these kind of like individual opinions in the reconstructing of community interests among all cases or the ICJ jurisprudence in general. Thanks.
Thanks. I'm Millie McCrath from Durham. I also have a question for Sally and Vin. I'm not coming at this from a place of aggression because I also work on community interests, but you have in your slide this coexistence, cooperation, community kind of progression. And that's something I really struggle with. Do you really see that that's the case? Like, you know, in 2020, 2025, can we paint this beautiful picture that we've all ended up in community?
Thank you so much, Martina, for asking the follow-up question to Joseph's. With respect to the changes in the rules of court, I assume you mean the changes to Article 85 or 86 about having discretion in terms of allowing. Okay. So I think that this is still compatible with the right to be heard, not at least because there was not necessarily an established practice of the court in terms of granting oral hearings in cases of mass intervention before 2022, 2023. So in that sense, I do think this is compatible with the right to be heard. Whether the court should change the way it organizes oral proceedings in those cases, I still think that it cannot presume from the start that participants would argue or interveners would argue in the same way and then necessarily curtail their rights or the time allotted to them. But of course, and I think the court has done that in the past, it always has to be weighed with other procedural principles, including the sound administration of justice and the equality of the parties. Yeah, maybe I leave it at that. And
Yes, okay, sorry. I'll just thank you for the question. I'll only stick to the one about this linear progression. So yeah, maybe I should have mentioned when I put it on the slide that it's obviously it's aspirational, right? It's a notion that is being promoted by international lawyers and to work towards an international community. And I think I'm often reminded of political scientists and historians always make fun of international lawyers for using the term international community unironically. But but on the other hand, it is still being promoted, and you do find, of course, that the notion of an international community finds a lot of appeal, and it also comes back in rhetoric. I mean, even, China promotes a shared common future of humankind, so there's an implicit community in there, and there are also still other notions that are being promoted. But I would definitely not say that it's a reality at the moment, unfortunately. Yeah.
Yeah, a couple of brief comments again on the community interest question, and then I'll come back to Veronica's question. I think I would say that I maybe am quite optimistic when it comes to the whole question of, is community interest part of international law now? Obviously, everyone has a slightly different idea as to what community interest actually means, but I think we can count our victories in this regard. There are a lot of things that are generally accepted now, concepts of community interest, whether that's the operation of obligations erga omnes partes, to a slightly lesser extent obligations erga omnes, as I think we will hear from Priya at some point. There are, we have many things have been established, many community interest related concepts have been established, also substantive rules that people kind of consider as fitting within the community interest, that would have been unthinkable decades ago. So whether that development is linear, I'm not sure, but there is certainly a development that can be seen. And then on Veronica's question, I can't say that. So methodologically, we didn't separate between, what they're actually titled as, so declarations, separate, dissenting, etc. One thing that I think is quite interesting that I kind of skimmed over in the presentation for the interest of time, but is this question of the extent and scope of separate opinions, because Article 57 really only refers to dissenting opinions, not separate opinions more generally. The rules of court refer to whether dissenting from the majority or not, but Article 57 refers to if the judgment does not represent in whole or in part the unanimous opinion of the judges, then any judge shall be entitled to deliver a separate opinion. And then, as I kind of very briefly referred to, we have this difference of opinion between certain judges, as was demonstrated very well, I think, in the Southwest Africa cases, where some judges have this idea that a separate opinion should really be about how that particular judge differs from the reasoning of the majority, and other judges that take a much broader perspective, like this is my stage, I'm going to say what I want, kind of thing. And I do think we're moving maybe towards more of an acceptance of the latter. And there, I'll try and wrap this up for more questions to be possible, but there I think you see obviously more space for engagement with things that haven't been mentioned by the majority, or that have been mentioned but only at a very shallow level. Thanks.
Great. There are no more questions, but this was an excellent discussion. Thank you so much all for participating and to the panel for the great presentations. Okay, so I'm being told we have coffee outside, a 15-minute break, and then we're back here at 3:30 for the next session.